Good afternoon. My name is Dave Jones, and I have the pleasure of chairing Budget Subcommittee Number 1 on Health and Human Services. I want to welcome everyone here this afternoon to this oversight hearing, which will delve into the issue of provider complaints to the Department of Managed Health Care regarding underpayments from health maintenance organizations. I believe we'll be joined in a little bit by my colleague, Mr. Bell. And just to set the stage for this hearing, we do have an agenda which we are making available to members of the public. It had been our hope that the first panel would consist of the Department of Managed Health Care, and I just want to make sure that there isn't anyone here from the department. We did invite the department to attend this hearing, and the hearing was duly noticed in the file. Copies of proposed questions were sent to the department. I'm very disappointed to report that the governor's office communicated with the committee and advised that they would not be sending someone to participate in the hearing. We offered to reschedule the hearing to accommodate the department, and the communication we received back was that they would not be willing to provide someone to attend the hearing despite our offer to reschedule the hearing. I have to say that I am not only deeply disappointed but extremely frustrated at the administration's response to the legislature's legitimate request to hold an oversight hearing on this matter. This is not a new issue to the department or the administration. In fact, in February of 2009, as the chair of the Assembly Health Committee, I wrote the director of the department, Ms. Cindy Ennis, regarding concerns that I had as it related to complaints by providers, in particular emergency room physicians, and the status of the department's response to those complaints, complaints which dealt with underpayment to the emergency room physicians by various health maintenance organizations. In March of 2009, I received a response from the department that said that these complaints were being duly considered and that they were in an enforcement process. In fact, it wasn't until the second half of 2010 that these complaints were addressed, but I might add, I don't believe that they were addressed to the satisfaction of the providers or this committee, and I anticipate we'll be hearing some testimony about that. But I cite this exchange of letters, which occurred in early 2009, to add further support for my view that this has been an issue that has been raised with the department for some time now, both by the provider community and by members of the legislature. And the department certainly cannot claim, nor can the administration claim, a lack of prior knowledge or understanding of these issues. Moreover, the department has units that are ostensibly funded by the legislature to deal with provider complaints. And so this is something that is certainly within the purview of the department. It's something that they have direct knowledge about and would not require any extraordinary effort on their part to be prepared to answer questions of the legislature in this regard. So I think it's quite extraordinary that the department and the administration have both decided not to participate, and I will have a few things to say about that further at the conclusion of the hearing. In that the department is not present, I think what we'll do now then is move to the second scheduled panel on our in our hearing, which is a panel which consists of emergency physicians who will share with the committee some of their experience with submitting complaints to the Department of Managed Health Care regarding underpayments from HMOs. And if I could invite that panel forward at this time, please, if you'd be so kind as to take a seat here in front of the dais and make yourselves comfortable. We've got plenty of seats and plenty of microphones. And we have a order set forth in this agenda of individuals to speak, although if there's a different order that the panel would be interested in pursuing, that'd be fine too. I think in the interest of time, both to make sure that we have a chance to hear from everybody, and also the members of the public, if we could perhaps limit the remarks from each person to about 8 to 10 minutes. And if I have any questions, I may very well hold those to the end of all of the presentations rather than interrupting the flow. So with that, let me also welcome my colleague, Mr. Bell. It's a treat to see you. Thank you for joining us. We're just starting the second panel since the Department of Managed Healthcare declined to participate in the hearing. And with that, maybe what I might do is just ask the panel to introduce themselves and tell us in what order you'd like to make your presentation.
Hi, thank you. My name is Andrea Brault. I'm a practicing emergency physician and president of the California chapter of ASAP.
Good afternoon. My name is Andrew Selesnick. I'm an attorney. I'm a partner with the Los Angeles office of Michael and Robinson and chair of the firm's healthcare department. I represent a large number of emergency physician groups and reimbursement matters.
Hello, my name is Dr. Michael Foreman. I'm a board-certified practicing emergency physician in the state since 1983. I practice at Tri-City Medical Center in Oceanside, and I'm here because in addition to practicing medicine, my group has done its own billing since 1985, and so I'm fairly knowledgeable in the issues affecting medical reimbursement and emergency medicine.
My name is Tim Madden, and I'm representing the California chapter of the American College of Emergency Physicians. I'll be pinch hitting for David Strumpf, an emergency physician from Santa Barbara. And I think what we'd like to do is have Dr. Brault start off and give her presentation, and then we'll move to Andy Selesnick. I will follow Mr. Selesnick and give some brief comments, and Dr. Foreman will follow myself. And then we'll wrap up with Dr. Brault. I believe my comments will be shorter than 8 to 10 minutes, so if it would be okay with the chair, I might defer some of my time to Dr. Brault, but keep the total amount of time within the 8 to 10 minutes for all of us.
Great. So we're going to start with Dr. Brault and then Mr. Selesnick. And I note that we have, I think, misidentified the name of the firm. It's Michelman and Robinson, correct? Right. We mistakenly said Michelson and Robinson. And then we'll go to Mr. Matt, pinch hitting for Dr. Strumpf, and then Dr. Foreman. Very good. Dr. Brault, would you like to start?
Yes, thank you, Mr. Chair, and other members of the committee for having us here today. I'm going to start out by explaining a little bit about what we do and why the safety net is particularly vulnerable when 1455 is not enforced. As many of you know, although there's some new faces in the audience today, the emergency medicine safety net in California is particularly vulnerable. There is a group that looks at emergency medicine across all states, a group consisting of some insurance companies, a charitable foundation, and emergency medicine. And California is ranked 51st out of all the states in access to care, meaning that in terms of the number of people that need access to an emergency department versus a number of emergency departments, emergency physicians, nurses, beds available, we're coming in last. And I don't know if people really understand that. I mean, it doesn't really affect you until you have to seek emergency care and you're waiting for hours upon hours with your injury, your pain, your child crying, whatever that is. So while we've spoken for years about how our safety net is degrading, we are in a very bad place. We have no surge capacity, no ability to handle a bad flu or any sort of serious event. We're also the ones that take care of everyone. We have what's called the EMTALA obligation, meaning we take care of every person who presents and stabilizes their emergency. That doesn't mean we have to take care of a bug bite or whatever. We stabilize the emergency. And people seem to think there's a lot of stuff coming to our doors that's unnecessary. The CDC checks it every year, and that number's down to less than 10%. So it's not that we're being overrun with people who are not sick or not ill. That's simply not true. People are coming to us because they're sick or they're in pain. And our ability to handle that capacity is now 51st out of all the states that this committee examines. And what happens when 1455, which is actually a great tool is not enforced, is we end up with longer wait times in our emergency departments. Just like any small business, if you have no revenue coming in, you have no staff at some point. So we're having longer wait times, which if you're the patient waiting, that's significant for you. When the capacity or the number of patients exceeds the capacity, at some point the emergency department has to say no more, and they close to ambulances. What does that mean? Well, if you're the person in the ambulance, that's significant. That means you're riding around looking for a place to go that's open. The other thing that happens is the doctors who were on call to the emergency department at some point become also overwhelmed when there's no enforcement of the insurance regulations that talk about how you get paid. And because they have some option of being there or not, at some point they say no thank you and stop taking call. At some point this is really creating a significant problem for those of us that have to be there, to the point where it's impacting the patients and their ability to get care. Longer wait times, ambulance diverted. At some point the care is actually impacted. And when I talk about 1455, what we're seeing is for an emergency department or an emergency physician, unlike an office-based model, we don't really have relationships with those payers. It's a very complex sort of delegated payment model. The money goes in at the highest level, and I'll just use some examples because I'll use terms that we're familiar with, say Blue Cross or Cigna or HealthNet. But the payment for the emergency physician comes out somewhere along the way, like a pinball game. The payment's going to come out from a medical group labeled, and I'll use, again, terms that people know, not to pick on people, but terms that people know, La Vida or CareMore or Global Care. But for the emergency physician, we just see the patient and then hope that somebody's supposed to pay us. But in the delegated care model, it's a hope. And we have to rely on the DMHC to enforce the regulations that are there so that the payment actually exists for us. But what's happening now is it's not being enforced. Those medical groups don't always pay the claims, especially if there's problems with financial solvency. They don't have to pay us. There's non-enforcement of 1455, and at some point those claims are going unpaid and making the safety net even more tenuous than it already was. And part of the problem is because our claims are so much smaller than, say, a hospital claim, which can be exponentially larger, for us to try to fight the non-payment of those claims is very difficult. It's expensive to fight the non-payment, and Dr. Foreman will address that towards the end of our talk. Because they're so much smaller and it's so expensive to dispute or fight the non-payment, we're really almost powerless if we can't rely on the DMHC to fight for us. So we've been working with the DMHC, and we have filed, and there's a couple pages there for you, complaints for medical group, time after time after time after time, and all we get is case closed, case closed, case closed, with no change in payer behavior. So we're stuck, our doors are open, we're providing care to patients, but we're not seeing any change in payer behavior. So we're having this sort of ongoing issue where the claims are either not being paid at all or they're not being paid consistent with a fair payment pattern. And because of our small business model, we don't have a way really to fight them that's fast or effective. And so we're relying on the DMHC to do that for us. And also in your handout, there's a picture of a bar graph. And so when balance billing, or the ban on balance billing, came into effect, and I think everybody was in agreement with not having the patients be in the middle, but we were told that 1455 would be enforced and that payers would not be allowed to change their behavior. But what you can see is if a ED group has the medical group, that sort of almost pinball effect of the payer paying, some of these payers drop their payment by half. And so what's the small business model supposed to do? All of a sudden they have less revenue, they're not able to staff to meet the demands of their department, more patients are coming in, they need an ability to put more providers on the floor of the emergency department, and yet payers are not paying and they don't have recourse. Unlike a private doctor's office who can just hang a sign, I am no longer seeing and I'll just pick a name, Vantage Medical Group patients. He can choose to do that. We can't. Even if they don't pay us, they're going to keep coming in to see us. And at this point, I think I'll turn it over to Mr. Selesnik, who can give a great example of what happens when it goes on and on and on with no response.
Before we do that, can someone share with us what you understand AB 1455 requires?
Can I take that one?
Absolutely. Right. Because in your remarks, you referred to it several times. I just think it'd be useful to get that out there.
Oh, sure.
Generally.
Yes. So what 1455 requires from the payer is a fair payment pattern and a certain type of claims payment behavior. We could be here all day, but there's a certain way that they're supposed to pay their claims, a timeliness requirement, and a requirement that talks about how many claims they're supposed to pay based on the initial billing. In other words, they don't deny or ask for more information. And then it has a payment standard.
Okay, very good.
And if I could go on a little bit further, what we're seeing is for the health plans, the very first level of payment is most of the health plans, I would say the majority, abide by 1455. So that's not where the industry is struggling. But when we get into what we call the delegated payer model or the risk-bearing organization, the health plan has turned and given money to a medical group and said you will be at risk for payment of the emergency department claim. So now part of the money has come out of the system, some profit margin has come out, and now there's another layer down that's responsible. It's at this level that we're having tremendous difficulty. Having the claims paid on time, having the claims paid as billed, having the claims paid not just as billed by CPT code, but by the dollar amount. Or even if it's Medi-Cal, where it's a set fee schedule, everybody knows what it should be paid as. It's turned in almost, I'd say, the wild, wild west. But you don't even know what you're going to get paid. It's a free-for-all at this point for some medical groups, and we have no way, we have no leverage. We have nothing to fight back with at this point.
And does this problem exist both for work done by ER physicians in contract and out of contract, if you will?
I know that it does exist for some contracted claims because I'm getting that feedback, but it's a little bit less so. But having said that, if you understand the emergency medicine model, there's not as much contracting in the industry. So, for example, in an office-based model, the way that an office-based doctor drives business is he goes out and gets as many contracts as he can because that's how he drives business. But in an emergency medicine model, patients come to you because they're suddenly injured or sick or whatever. They don't come to you because you hung and I'll use an example, Blue Cross shingle out. So, emergency departments don't typically have as many contracts as, say, an office-based provider where almost all of their patients are contracted.
Okay, that's very helpful. So I think next we're going to hear from Mr. Selesnik.
Thank you, Mr. Chair, and members, for the opportunity to come today and speak about how the Department of Managed Healthcare has, I think, failed in its mission to protect providers and patients through an abrogation of its responsibilities, and that further legislation and oversight can hopefully restore some balance. We already know that the department is required to regulate the payers, but at least in my view, from where I sit, they've become far too comfortable in that relationship. Mr. Chair, you mentioned early in your remarks about one of the enforcement actions that the department had taken this year. And that's the one example that I've chosen for today, which involves Levita Medical Group. Levita Medical Group, a little background on them, they're a Southern California-based independent practice association, which means for the most part they don't actually provide any services. They act as a middleman. They contract with various health plans to obtain what we call lives. They're assigned certain patients, and they get generally speaking, a dollar amount per member per month. And then they're responsible for paying for the care of the members. Levita is actually three different entities that more or less run the same. There's Levita Medical Group and IPA, there's Levita Multi-Specialty Medical Clinics, and there's Prairie Medical Group. But for purposes of today, we just call them Levita because that's the way they're treated, one and the same. At its height, it had about 100,000 lives assigned to it, primarily in Southern California and some in the Central Valley. It's always sort of had a checkered history in terms of its reputation for not properly reimbursing claims, especially non-contracted emergency physician claims. It primarily primarily has members who are with Medi-Cal, so it's a Medi-Cal managed care plan, although they do have some commercial and some Medicare as well. Their continued problems in terms of proper reimbursement, we believe, led to sort of an access to care issue because doctors don't want to contract with somebody who's not going to pay them. Their website, when it was up, said that they were committed to providing quality care and paying providers in a timely basis, and I think they've shown that to be inaccurate. Their significant problems started roughly in 2007, where they failed to meet multiple financial solvency requirements set out by the Department of Managed Healthcare. These include not meeting tangible net equity, claims paid on time, maintaining sufficient working capital, and cash to pay claims. So essentially in 2007, they didn't have enough money to do business. After approximately, I believe, 10 to 12 months, the department finally got around to forcing them to enter into what they call a corrective action plan. This is something the department requires IPAs like Levita and others to promise that they're going to do certain things. What's their plan for turning their finances around? Because when they don't have enough money to pay claims, providers aren't getting paid, and the patients are losing access as well. In 2008, they entered into the cap, we call the cap, and by the time they did it, they were about a year behind in paying some claims. The cap was not made public, which I think was a mistake because I think the providers who are owed money are entitled to know what sort of financial situation Levita was in. Although the department does post on a quarterly basis reporting requirements. For example, Levita had to set forth each quarter whether or not they were meeting certain financial solvency benchmarks, as do all other IPA medical groups, and that's where a lot of our information comes from. We learned recently that the department accepted Levita's cap, which provided it 3 years to get out of financial trouble. And from somebody who represents a large number of emergency physician groups and reimbursement matters, that's 3 years of not paying your claims because you have to move forward. They didn't have enough money they didn't have sufficient working capital. How could they pay their claims? So the department first agreed to that, which I believe was a mistake. The health plans were also made aware of the cap. And in fact, Levita whenever it made reports to the department, it also made reports to the health plans. So everyone was well aware, except for the providers, what Levita's financial situation was. Yet there was no part of that plan that said, well, in the meantime, health plans, you're going to have to pay the bill because the providers are entitled to get money. Because the health plans continue to pay Levita every single month and believe that their obligation stops there. We disagreed. In 2009, Levita had made very little progress. In fact, in some areas, I think they had gone down on certain of the benchmarks. Every quarter, they would report to the department that they had not met the benchmarks. Every quarter, they would report to the health plans they had not met the benchmarks. But the department did nothing. Nothing at all. They didn't communicate with providers. There was no order by the department that the health plans reimburse, in particular, emergency physician providers who were in, as Dr. Brault was discussing, a particularly vulnerable situation, because unlike an internist who hasn't been paid by Levita, they can tell the patient, I'm sorry, Levita doesn't pay me, either you can pay me cash or you can go somewhere else. Emergency physicians don't have that choice, and Levita and the health plans took full advantage with, I believe, the department's, if not express, a tacit permission to do so. The real meltdown in this case took place in October of 2009, some 2 years after Levita had stopped meeting all of the department's benchmarks. Levita's lender, a company by the name of Truxton Financial, went into bankruptcy, and the trustee seized $4 million out of Levita's bank account. According to the deposition of the CEO of Levita, which I took about a month ago after obtaining a court order, he said at that point, essentially, they were out of business, more or less. He said that he notified the department of that and the health plans, told them that they really didn't have the money anymore. There was no access to capital in the markets, which, given the economy, is not a big surprise. And you would have expected at that point the department would have taken some immediate action, forcing the health plans to terminate their contracts, or the health plans themselves terminating the contracts. But instead, it was business as usual, with the real sufferers being the patients, because now there were a large number of claims that were not being reimbursed in any amount. And of course, the emergency physicians and other on-call physicians who were treating these people and not getting paid for it. Between October of 2009 and roughly June of 2010, the department continued to do nothing. A number of providers, I believe, filed complaints with the department. The health plans were sent letters telling them that Levita wasn't being paid. And I think just as importantly, from a transparency perspective, the providers didn't know that Levita was really out of business, that the lender had come in and taken, the trustee had come in and taken $4 million. They had no idea. So they're continuing to do their job, their EMTALA obligation, and treat everyone. Finally, I believe some 9 months after this pivotal event, this what we call death blow, occurred to Levita, the department finally could wait no longer and ordered the health plans to terminate their contracts. But when they did that, they could have done a lot of things. They could have said, you have to do that, and because you made a business decision to continue paying an entity that you knew was financially insolvent under all our benchmarks for years and years, health plans, you got the benefit of that because obviously you weren't paying them enough money. Therefore, you should go and you should reimburse the emergency physicians and other physicians for their unpaid claims. But they didn't do that. But they essentially let the health plans keep all the money that they saved in not paying Levita and not paying the emergency physician claims. And at least on my unofficial tally, it adds up to millions and millions of dollars. When Levita finally went out of business, they turned off their phone, and in the words of their CEO, they currently don't have funds to buy a stamp. The health plans, some health plans paid a few of the claims. Most have taken the position that Levita was fine and they don't owe any money. I think that had the department performed their regulatory duty and had not had such a comfortable relationship with those that they're supposed to regulate, then we wouldn't be, at least I wouldn't be sitting here today discussing this particular issue. I think it's a systemic problem that exists. I've heard no good reason why the department wouldn't take action at any point, why they would consistently side with the payers by doing nothing. And I personally find it a bit disappointing that they're not here to at least hear what others perceive as some shortcomings and hear their views on it. I don't think it's necessarily a question of resources. and I'd quickly like to give you a couple of examples. I think it's a question of priorities. When the balanced billing regulation that Dr. Brault was referencing was enacted in roughly October of 2008, emergency physicians can no longer balance bill. If the enrollee or the patient belonged to a healthcare service plan or an IPA, someone who is regulated by the department, just couldn't do it anymore. The payers took the advantage because now the patients were never calling them to complain about their low reimbursement. And whenever a bill got out, by accident or otherwise, they would immediately turn around and send it to the department. And the department within weeks would send letters, staff counsel would send letters to the provider saying, you're not permitted to balance bill. But what I find troubling about this, besides the dual standard of waiting years and years for an entity that they know is financially insolvent before they did anything, as opposed to a provider who sends a bill, is that they don't take the care to see that what they're sending was accurate. In one particular instance, it turned out that the payer was out of state. It was a Blue Shield entity out of state, and therefore was not even subject to the department's jurisdiction. Yet they still sent the letter. When they were told that this didn't fall under their jurisdiction, they wrote back and said, well, yes, it's out of state, but you even attempting to balance bill is an unfair billing practice that we might look at. And so you have, I think, the two polar extremes of really going after the physicians who provide the core of our safety net in an area where they don't even have jurisdiction, versus protecting the multi-billion-dollar health plans and the profit-driven middlemen, the IPAs, at the same time. And I think with some legislation, like I said, some regulatory oversight, it's something that can be changed and should be changed.
Thank you very much. Thank you. I think next we're going to hear from Mr. Madden.
Mr. Chair, Assemblymember Bell, Tim Madden, representing the California chapter of American College of Emergency Physicians, and I'm sitting in for Dave Strumpf, who is an emergency physician with South Coast Emergency Physician Group down in Santa Barbara. He was scheduled to be here, but unfortunately, he had to cover a shift in the emergency department, so he's unable to make it, and he sends his apologies. South Coast Emergency Physicians Group staffs the emergency department at Santa Barbara Cottage Hospital. They're a level 2 trauma center located in downtown Santa Barbara. Dr. Strumpf has been practicing emergency medicine at Cottage Hospital for over 25 years. Santa Barbara Select IPA is the organization that I'll be focusing on. As Mr. Selesnik described, this is an IPA, another organization whose sole responsibility is to arrange and coordinate care for its enrollees that are in the Santa Barbara area. This very same group had previously declared bankruptcy twice, yet they continue to come back and continue to do business in the Santa Barbara area. Dr. Strumpf's group had been contracted with those organizations before they had declared bankruptcy and cost him and other physicians hundreds of thousands of dollars. In 2002, this organization reemerged as Santa Barbara Select IPA. Once again, Dr. Strumpf decided to enter into another contract with them, knowing what had happened, but nonetheless, as Dr. Brault described, under the EMTALA law, their enrollees will be coming into the hospital. So he felt, let's give it one more shot. Later in 2002, Santa Barbara Select IPA called up Dr. Strumpf and unilaterally terminated his contract and said, we no longer are interested in contracting with you. The reason for that was, as no surprise, they began to have more financial problems. They told Dr. Strumpf that they were going to start reimbursing him at 50% of the contracted levels that he had been receiving just months prior. At this point, Dr. Strumpf did attempt to work with Santa Barbara Select, as well as the health plan, Blue Cross, who was the entity that was delegating enrollees to Santa Barbara Select, with no success. Dr. Strumpf actually was trying to pursue a contract directly with Blue Cross to have the Santa Barbara Select patients work directly with Blue Cross and be paid through Blue Cross. But Blue Cross had no desire to enter into that contract. Although Dr. Strumpf actually did have a contract with Blue Cross to take care of Blue Cross's PPO patients. So once again, Dr. Trump is making an effort to try and work with these entities to get something in place, but nothing is happening. So at this point, we're roughly into the end of 2004, 2005. Dr. Trump starts reaching out to the Department of Managed Healthcare, submitting literally thousands of complaints to them, begging them to help adjudicate these underpayments. Dr. Trump was told the department had multiple people as well as their enforcement division working to adjudicate the claims, yet Dr. Trump received little response from the department on what the status of those complaints were. His quote was, 90% of my emails sent to the department went unanswered. But what he was able to find out was the department took an interesting action at this point. They actually hired a billing expert to look at Dr. Strump's charges to try and determine, okay, where is Dr. Strump charges way out there? Are these reasonable and customary charges? Are these fair charges? The billing expert actually came back and determined that Dr. Strump's charges were fair. And as this news came out to Dr. Strump and thus sharing it with Cal ASAP, we finally felt we were in a place where we had the example that we've all been waiting for, the evidence to show that this group was blatantly underpaying Dr. Strump, and we would have a strong case for an enforcement action. We thought this was going to be it. This is our opportunity. This is the department's opportunity. At no time during the 4-year period starting that 04-05 time frame did DMAC ever adjudicate one claim. At no time over the 4 years did DMAC take an enforcement action against Santa Barbara Select for the thousands of claims that they had underpaid. In 2008, out of nowhere, Santa Barbara Select started actually paying Dr. Strump's bill charges. So we actually thought that we had something here. There was no enforcement action that happened, but at least they're now paying the bills that he's sending in. Unfortunately, there was no word on what was to happen with the 4 years, make it 6 years of underpayments that had been occurring, or any type of enforcement action against this entity, since the department did have in their own knowledge from their billing expert that his charges were fair. Moving forward, as Mr. Slesnik talked about, when the balanced billing regulations came into place, we started to see a change in the marketplace overall, and specifically with Santa Barbara Select. It took them less than a month to change their systems to start paying Dr. Strump at the previous lowball standards that they had been doing for the previous 6 years. At this point, Dr. Strump had no choice but to go back to the Department of Managed Healthcare and ask for their help again. Dr. Strump reengaged with DMHC in 2009, and actually DMHC issued a cease and desist order against Santa Barbara Select and Blue Cross to freeze its enrollments of new individuals. And then the department did move forward with an action against Santa Barbara Select IPA. So once again, collectively, we're all thinking this is going to be it. Dr. Strump's in a good place. We have some good evidence to show that these are significant underpayments. There's a pattern in practice here. The department's going to issue the big hammer. As we went through the process and the action came down and the settlement agreement was announced, the settlement was that Blue Cross was released from the cease and desist with no other penalties. Santa Barbara Select was only subject to being forced to use the internal dispute resolution process that the department had designed to adjudicate any claims going forward. There was no mention of the years and years of underpayments that Dr. Strump was subject to. There was no other enforcement action taken against Santa Barbara Select IPA. Needless to say, Dr. Strump was shattered. His colleagues within Cal ASAP were nothing short of amazed. And this is an organization, the department, that we've continually had these struggles with, but nonetheless, this perfect opportunity that seemed to be in front of us vanished into thin air. Now, we've talked about the impact on Dr. Strump, but what does this mean to the patients? I was speaking with Dr. Strump this morning, and he's explained to me that the Santa Barbara Select patients actually have a higher utilization of the emergency department than any other group in Santa Barbara, which includes the health plans, but also includes other IPAs that are in the Santa Barbara area. And I asked him, I go, why is that? And he goes, well, Santa Barbara Select has made the choice that they do not invest in primary care. They have no access to urgent care services after hours, no access to ambulatory care. So what happens is for all of us who are working 9 to 5 and we would normally go into a clinic after hours, Santa Barbara Select doesn't provide those services. Thus, they go into the emergency department. This is the organization that we had all this evidence for that the department could have done something about. And what we're seeing is that the patients are the ones who suffer. They're the ones that are going into the emergency department when they should have access to primary care. This also translates into the on-call specialist And Dr. Strumpf was explaining to me that they only contract with one orthopedic group in Santa Barbara. And actually, that orthopedic group does not take any patients at Santa Barbara Cottage Hospital, which means that if you or I or one of our loved ones were an enrollee of Santa Barbara Select, we got into a trauma accident, some type of car accident, we needed orthopedic care, we would be forced to take into the Level 2 Trauma Center where we would be stabilized, but we wouldn't be able to get access to the orthopedic care we need until we were transferred over to Goleta Hospital. So once again, this is the organization that has made the choice not to invest in their own physician groups to get access to care. And my statement might be inaccurate to the extent that a lot of the physicians in Santa Barbara on the on-call side are making the choice to not contract with them because they know the level of payment that they're giving to the community of physicians, and folks are not choosing to contract them, similar to what Dr. Brawl had talked about earlier. So that concludes my statements, and Dr. Foreman will be able to talk to you a little bit about the department's internal dispute resolution process and some of the challenges that that provides, and it provides some additional irony to an enforcement action that requires Santa Barbara Select to use that IDRP. Thank you.
Thank you. Let's hear next from Dr. Foreman.
Thank you, Mr. Chair and committee members, for allowing me to come up and give you a little bit more background on the problems with reimbursement and the IDRP that emergency medicine is having. As I mentioned, I work at a community hospital in Oceanside, California, which is in San Diego, and we're very busy. Our emergency department sees about 70,000 patients a year, and we see patients among all demographic lines, a lot of indigent patients, patients on Medi-Cal, and we have Medicare and, of course, some insurance patients, although the latter number is dwindling as economic times are bad. And I think many members of the public don't understand that, with the exceptions of some teaching hospitals in Kaiser, almost all the other emergency departments are really small businesses of physicians. Hospitals do not pay their emergency physicians. We're independent contractors there. So whatever we're able to collect is how we're able to make a living. And there's been a balance in prior years between the ability to get reimbursement from either Medicare or private insurance, and which has allowed us in that balance to provide care to indigent patients. And among them, I'm going to include Medi-Cal, because our state is among the very last few in Medi-Cal reimbursement. And for emergency physicians in California, we make literally a few % profit on a Medi-Cal patient. So we, in order to continue providing emergency care in this state, we have to have this balance. And what's been going on since the balanced billing prohibition has taken effect is that insured patients, since we can't balance bill them or even enlist them in the help to get their bill paid, we're getting paid less and less and less as time goes by, because we have no way to force any reasonable payment, which is all we're really after, out of insurance companies. And the amount of money that we're talking about for emergency physicians in this state is a rounding, not even a rounding error in the insurance company's budget. We're talking about a few $100s per claim in terms of what they tend to underpay us. But in the ability for us to provide emergency physicians, that's huge. But for insurance companies, the money is very, very small. So we thought, when I testified on 2 hearings in front of Cindy Ennis when this balanced billing prohibition went into effect, she had guaranteed that we would have a form that would be cost-effective and it would be fair, so that emergency physicians, if the plans became abusive and started underpaying us, would have a way to get we want just fair payment for the services we're provided. And our average bills $350, $400, and we're talking about taking care of patients with strokes, heart attacks, major trauma, seizures, all kinds of things, and we get a payment of $150, $175, and then we're stuck because we have to. The next step for all of us is our billing company appeals it back to the same people who denied it in the first place. So the yield on our initial appeal is extremely low. And the way the IDRP process is set up is there is a fee for submitting claims to the IDRP. And you can't submit more than 50 at a time. And for example, the first claim, I believe they would charge us $25 for one claim, and then the amount that you would pay per claim goes way down if you bundle them. And so initially that sounded reasonable. But the problem with the IDRP is that there's no binding agreement of the health plan to participate. So what happens for us is, in order to, we first appeal to the health plan, and that is all manual. We have to go and copy the dictation, send an explanation of why we were underpaid, and then that goes to the health plan, then that comes back denied. Then my office manager looks at it, because we're not going to make a big case out of every one that we're underpaid. We look at the more egregious ones. She has to go through those manually, and then she shows them to me, and we pick ones we think are just absolutely ridiculous. Like I say, where someone is on death, about to die, and we save their life, and we get paid $110, something like that. That's the type of thing we say, well, this looks like a slam dunk for the IDRP. Well, we were told there's two places we can appeal in the DMHC. The one is called the Provider Complaint Department, and then there's the IDRP. The Provider Complaint Department apparently can issue a binding decision on the health plan to give us supplemental payment if they feel it is unfair. So in recent times, we submitted about 8 months ago 50 claims to the Complaint Division. And again, that's after we hand processed. We sent them we had to send a lot of forms filled out on why we were appealing these things. And in the course of 6 months, we got one determination that, yes, they agreed with that we were underpaid, and they sent additional money. The other 49 claims never got handled. They told my office manager that we just don't have the staff to do this. You better send this stuff along to the IDRP. Okay. We sent the other 49 claims to the IDRP, and those did get looked at with reasonable promptness, but we got only two types of responses. The first response from the IDRP on these claims was that the health plan didn't fall under Knox-Keene, and therefore it wasn't one they regulate, such as an out-of-state health plan, and therefore they couldn't help us. And the other two-thirds or so, they said, the letter came back saying that we're very sorry to inform you that the health plan is elected not to participate in the IDRP. So, sorry, we can't help you. So it cost us, and I did a pretty good analysis, about $40 per claim with all the manual processing just to submit a claim to the Department of Managed Health Care. So we knew all right off the bat we're in big trouble. It's very cumbersome. It's a lot of forms to fill out, a lot of killing trees and paperwork and that type of thing. But then to have 100% of our claims come back saying that we can't help you, it's a non-dispute process. So they set up a process where the health plan can elect not. I can understand if they're not subject to jurisdiction of the DMHC, then I can understand why we wouldn't get any hearing on that. But to allow the health plans to elect to participate, why would they? And so we have a non-dispute resolution process. So in terms of the general public, what's inevitable, we can all see this coming, is as insurance companies get more brazen and pay us less and less, the ability to have a business model for a small business where you have to pay your providers is getting worse and worse. So we're starting to have to make the staff skimpier in the emergency department. So if you want to get seen on a timely basis, it's getting harder and harder, because just like any other business, if you can't pay providers, you have to cut back on your workforce. And the other thing is, in the state, I'm sure you are aware, there have been emergency departments that have just been going out of business because of what's going on in this type of business model. And there are very few new emergency departments, since inpatient medicine is not where it's felt to be very revenue producing. So there's very few hospitals being built, which is where emergency departments reside. So what you're having is attrition in emergency medicine in this state. And the ability to recruit providers is getting extremely difficult when emergency physicians who are graduating see this type of environment in California. So I would really ask if there's anything that can be done to get a dispute resolution process that mandates at least the health plan to participate. That would be a good first step, as well as I won't bore you with the logistics of it. It could be streamlined a great deal, but I would just happy to even have some adjudication so that we would have a level playing field.
Thank you very much. Well, I have a couple of questions, and let me see if Mr. Bell has any questions as well. First, what you've shared with the committee is very troubling. I mean, what you've outlined is a situation that I think is ultimately not sustainable, and that is emergency physicians who are not given recourse to a fair process that will allow these claims to be adjudicated, and as a consequence, significant underpayment, which is then having direct impacts on the ability of emergency departments to hire, if you will, emergency physicians, to attract on-call specialists or to attract other physicians on an on-call basis. And that in turn has a direct impact on quality of care and access of care for patients, because if you don't have the specialists or other on-call physicians or emergency physicians themselves, then you're going to have longer wait times, lower access to care, and a greater likelihood of bad consequences for the patients. So I do think you've made a very compelling case for change. What we have right now isn't working. And I think as well, you've identified that while the DMHC regulation and the prospect decision on balanced billing has benefited patients and consumers, it is basically only half of the solution that we needed, because in promulgating that regulation and in making that decision, the court, that left the providers without any real recourse to make sure that they were being fairly compensated. And what you've described bears that out, because as you've testified to, you can actually see a change in behavior, either in the individual examples you've testified to or in the graph that you provided. Once balance billing was barred, you saw an increase in the underpayment frequency by the delegated payers, those contracted with by the HMOs to make the payment. So I'll note parenthetically that I and others recognize the unjust half solution, and I was pleased to co-author and floor manage a bill by former Senate President Don Parada in 2008, which sought to create some sort of a fairer interim payment and a adjudication process that would then allow for a fair resolution of claims. Unfortunately, Governor Schwarzenegger vetoed that bill. And I say unfortunately because I think it's left the system broken. On top of which, you've testified very eloquently and completely about the inadequacy of the existing processes at DMHC. And here I want to make sure I understand, because it sounds like what you're saying is that there might be a process that's authorized currently that could work if the department was actually enforcing that process. And that's the provider payment complaint unit process, where they do have the authority apparently to bind the delegated payor to pay at some reasonable level. Instead, what they've done is they have essentially stopped taking complaints into that process, or made it so costly or cumbersome for you to make those complaints that they're now shuttling you to the other process, which is the IDRP process, which is a process, though, where the delegated payer or the HMO can decline to participate. So it's not a binding process. Right. So you are in a rather Kafkaesque dilemma, which has all of the overtones of Alice in Wonderland as well. And so I think the specific questions that I had for you were as follows. One of which is, what specifically would you like to see DMHC do, given the existing authority that they have? I think one of you testified that you don't believe it's really a resource problem, it's more a problem of will, that there is authority for them under the provider complaint process, if I have the terminology correct, or the provider complaint unit process to bind HMOs or delegated payers. And so I'm just curious, I mean, given the existing authority, what would you like DMHC to do? Any of you can answer.
Yeah, if I could take a shot at that, and then you guys, gentlemen, could fill in after me. On the last page of the handout, we actually had a few suggestions there. For example, when we met and presented to the Financial Solvency and Standards Board, one of the things that we brought up is once you've started into a corrective action plan with an RBO, particularly an RBO, but I suppose it would apply to a health plan as well, is we need, well, specifically to the RBO, we need you to de-delegate the claims payment process for the emergency or the EMTALA obligated providers. When we listen to the questions that were being asked and the information being provided back to the DMHC, they're just not going to know how many claims are going unpaid or what's not being paid consistent with what was charged. And there's being so much damage done right now to the safety net. There were a couple of slides that we didn't get to, but Mr. Selesnik outlined very nicely the length of time that transpired during the Levita meltdown, we'll call it, and that whole time that there are claims not being paid involving the safety net, and now that probably will likely never get paid unless groups get together and institute fairly expensive legal activities. And so one of the things we brought to Director Enos is you have to come up with something where the health plans de-delegate fairly quickly, because once they become aware of it, it's a problem that's likely gone on for 6 or 9 months before they become aware of it. Something else that would likely require a change in their agenda or their will is true enforcement of 1455. Like I said, I think it's a very good piece of legislation, very specific requirements about the timeliness of claims being paid, how many claims can they deny, how they have to deny a claim, that kind of thing. Admittedly, the reasonable and customary definition, the actual amount of claims payment, is still a little bit gray, and we're struggling a little bit as an industry with that. But if we look to that current health plan behavior, it's, as we say, between the goalposts. For the most part, their payment, maybe it's not 100% of the provider's charges, but it's fairly close. It's not crippling the industry the way the RBO's behavior is. So there has to be a will to enforce that. When they get a complaint through the provider complaint unit or several complaints through the provider complaint unit, as we know they have because we talked, wow, is this medical group doing the same thing? Did you complain? Yeah, we all complained. And then we see no response. We need them to respond when we start to wave the flag. Does anybody else want to take a few of these suggestions?
Well, first, I would second your statement that if that legislation had passed, that would really obviate the need for all of this, because the process obviously needs to mandate both sides participate and be fair. But realistically, if this thing would get going, it would be many, 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 many claims. And that's really not cost-effective for the doctors, for the state, or even for the health plans. So I know with the last administration, Governor Schwarzenegger wasn't willing to sign that, but that might be one avenue that would really obviate a lot of this, because the process is going to be cumbersome, and it's going to sit there and argue with a paper document what this is worth, what is the definition of what's reasonable is subjective, and that's the whole problem with the whole thing. But again, I'll go back to what Dr. Brault says. At least they need to, number one, act when they know there's a problem, and secondary, have it be binding.
So if the legislature, well, let me back up a second. I mean, DMHC contends that they don't have authority to make the IDRP process binding. I'm wondering if there's any contrary legal opinion you have about whether DMHC can make that binding.
We don't have one. It's just in recent conversations that we've raised the issue of how do we make it binding. So that was an opinion expressed by some of the folks in the department. But yes, I think it'd be a good idea to maybe look into that a little bit further. So this is all within the last month or so.
So because basically it strikes me, the legislature is funding DMHC to have a process called the IDRP process, which is basically a arbitration process, and yet one party can elect not to participate at all. in which case there is no sanction as far as I can tell, and providers have no recourse because the value of these claims, which you've indicated in your testimony averages about $350 to $400 or so, maybe you're being paid $150 or so, is so small that your ability to go in then to court and adjudicate each of them individually is virtually non-existent because the transaction cost associated with doing that, I mean, even I think you testified a moment ago, even the cost of making these complaints to DMHC one by one costs you $40, let alone filing an action, say, in Superior Court, which leads to another question. What about small claims court? Has there been any effort to try to take these actions to a small claims court? And I'm just curious about what the experience has been there.
I don't think there has been experience, but I have a date in small claims court in January, which is really not what I like to do. But I'm desperate. My group doesn't know what else to do because we feel like there's no recourse. And then, of course, Mr. Selesnik advised me that even if we win there, then they're going to appeal to Superior Court. And so...
Where you'll have to have a lawyer.
Yes, and so...
Cost you a lot.
I think so. The answer is, that's where I'm going to be in January.
Right, which is, actually,
it's just ridiculous.
I'd rather have you in the ER room treating someone than standing in front of a small claims court on a case-by-case basis, seeking to adjudicate a $200 difference or $300 difference, which is a significant difference, but, and certainly when you add it all up, it's significant, but the amount of time that you're going to have to spend doing that takes you away from providing the services that you've been trained to provide, which is absolutely ludicrous. Before Mr. Bell leaves, let me make sure he doesn't have any questions for the panel. Okay, great. Thank you, Mr. Bell. Then the other question I had was whether there has been any other litigation outside of the small claims context, any track record or what's been the experience in going to Superior Court to try to litigate these claims.
I'll take that one. We regularly sue the payers on behalf of a large number of groups. Obviously, there are some significant costs that are involved in that, and I think we've had a very good track record. It's the court system, so it takes a long period of time, and certainly the payers, they will fight every step of the way, no matter what their reimbursement or their billing practices are. There was one recent case involving a county organized health system in Kern County, and I had a client, and this is all public record, so I can say it, but a client who was seeing approximately 700 of their patients every month. They routinely were down coding. That is, that if it was a heart attack at level 5, they would pay it at a level 3, and it was Medi-Cal, so it was even lower. So we ended up suing them. They turned around and spent, by our calculations, approximately $8 million on an audit to try and allege that my clients had upcoded, that they had inflated the codes. When we obtained information through the Public Records Act and exposed it, it turned out that the maximum amount that they could have gotten over the same period was about $2 million. And that would have valued our services at zero. So they spent $8 million on an overpayment audit where the most they could have recovered was $2 million. And eventually they settled it and paid my clients a significant sum of money and an ongoing contract that they felt was fair going forward. It shouldn't have to go to that, but that's what the arena does hold.
Of course, the irony that hangs over the discussion and yet bears mention, the elephant in the room, so to speak, is that the Schwarzenegger administration ostensibly is an administration which has set as an avowed purpose the reduction of court litigation, and yet they have, through their unwillingness to enforce existing authorities and their unwillingness to create a process that would allow for something short of court litigation, thrown ER physicians back up against the wall and give you no recourse but to go into court, and yet they say their stated purpose is to try to avoid precisely that. It's very ironic. Yes?
If I could just
if not,
add something else.
Tragic.
And this is something that we've met with Director Enos on multiple occasions. I mean, truly, if you only have 50 claims and you're disputing $100, chances are you let that go. And Mr. Selesnik brought up a good point. Most of us are dealing with hundreds upon hundreds of claims at issue with that particular group each month. So a process that deals with 50 at a time does not help us. A process that requires us to file one at a time really doesn't help us. And so we need a process that lets us work with hundreds, if not thousands, at a time. Because that's, a payer doesn't, just, down code or not pay one today. They set their system to do it every time they touch the claim. And so this is why we end up hiring someone like Mr. Selesnik. I've got thousands to address.
So if the legislature were to, through the budget or through legislation, direct DMHC to make the IDRP process binding, although I think there's still an open question as to whether they might not currently have the ministerial authority to make it binding, which is something I think is worth exploration. But let's just say, for the sake of argument, that they are correct, that it's not within their existing authority to make it binding. If the legislature were to give them that authority, either through some sort of budget control language or through separate legislation, and that IDRP process was not only binding but allowed for the submission of an aggregate number of claims, would that, from your perspective, be a potentially workable process?
I think that would be very workable, but I think that it's still not going to be, ultimately, it's not going to be cost effective for the state to do that, because someone's going to have to process literally thousands of claims if this ever were seen by emergency physicians as an avenue where we could appeal. I think most groups can't afford to hire attorneys to fight for them. My group in San Diego had a situation a few years ago where the county of San Diego, for prisoners, the most difficult patients to deal with, they decided they were going to pay us below Medi-Cal rates. And my group ended up, and we sued him. It took a couple of years, but the judge ruled that our fees were fair and reasonable, and we won that battle. Of course, we didn't make any money because of the cost of litigation. So, having attorneys involved is really not optimal. And I would go back to what I mentioned before. If you can somehow revive that bill that you and Mr. Peralta had, put forth, that's really the best way to handle this.
Okay. Let me see now if there are any members of the public that would like to testify at this point in the hearing. We're happy to hear from others who wish to comment or wish to share. One of the panel just stay where they are for the moment. But if you want to use the microphone here, that'd be wonderful. Yeah.
I get a choice. That's nice. Hello, this is Amory Benitez with Planned Parenthood Affiliates of California. I'm going to keep my comments short because a lot of things have already been said. But wanted to point out that community clinics also have issues when it comes to getting reimbursed. Since the implementation of Medi-Cal managed care, our community clinics have had issues with receiving underpayments or non-payments at all. It's been our experience that when our clinics bring problems to DMHC, and if they are engaged, we have positive outcomes. Our biggest concern is that there is no systematic change to prevent future problems. Community clinics receive a community clinic rate, which is often ignored when we are reimbursed and also requires constant re-education. As a result, our clinics spend much administrative work and time to be accurately reimbursed. Before DMHC recognizes a complaint, we must navigate through the plan's complaint process, which you all spoke to. Oftentimes, we bounce between the IPA and health plans, and this back and forth results in unnecessary workload and delay in payments. Once we've exhausted that process, then providers can file a complaint to DMHC, but we have to provide all this proof along with that to show that we've exhausted their complaint process. And this process is done by a case-by-case situation, so it's not resolved in a systematic way. So that proves to be a problem time and time again, because like I said, it's a constant re-education, it's a constant amount of work, constant amount of time, and it's a huge loss on our administrative end. And this also lack of systematic change proves to be a problem because of turnover, both at DMHC and within health plans. So if something is resolved, everybody forgets about it, and you have to do it all over again. So due to, and again, it's a very much long process. As we move forward with healthcare reform implementation, more and more providers will rely on reimbursement from health plans. So we recommend to DMHC, and as part of your thoughts and consideration here, that DMHC considers systematic fixes to prevent future problems. Otherwise, this is going to compromise providers' ability to serve millions of new patients who are entering both the exchange and Medi-Cal.
Thank you very much. Thank you. And I think that was an excellent point, which is our focus has been on a particular set of providers, emergency physicians, in part because of the unique circumstances that they face under federal law, under EMTALA, which is to serve everybody. But the problems that you have surfaced are not unique exclusively to emergency physicians. They apply to community clinics and other providers as well. And the problem is likely to get worse as we move down the road of moving a larger share of patients into managed care. The administration and the legislature have submitted to the federal Department of HHS, specifically to the Center for Medicaid and Medicare Services, a waiver application that would allow us to, in essence, move the aged, blind, and disabled in the Medi-Cal system into managed care. Both in that system as well as with the standing up of the health insurance exchange, we're likely to see more people moved into managed care, and as a consequence, a greater likelihood of seeing the sort of problems that we've talked about at this hearing, which is not only underpayment, but the absence of any mechanism to seek fair payment. So, if there's no one else from the public who would like to testify at this time, I think what we'll do is wrap up. I want to thank the panel for your testimony and the members of the public as well who have come to the hearing. It was very illuminating. It's also very depressing because what you've identified is ultimately a system in crisis and one that's not sustainable and one that has very direct implications for patient care, for the ability of hospitals across California to attract the best and the brightest ER physicians, to retain those physicians, to make sure that we can have other physicians on call and specialists on call. All of this is implicated by the systemic unwillingness of delegated payers to pay and the absence of any real remedy for emergency physicians and other providers to seek a fair and reasonable payment. The solutions that have been outlined, I think, run a spectrum. One is to introduce legislation that would, much as was the case in the 2008 measure authored by Senator Parada and co-authored by myself, provide for an interim payment standard and some adjudicative system following the interim payment. In addition, other ideas that we've talked about at the hearing that have been advanced include making sure that if the provider complaint unit is going to be used, making sure that it has adequate resources and that it's able to not just take complaints on a one-off, one-by-one basis, but actually deal with groups of complaints. Another idea that's been discussed as a possible solution is to change the IDRP process and make it mandatory and binding, and don't allow the arbiter to use criteria for determining fair payment levels that are outside existing law, and use unbiased arbiters acceptable to both parties, so we have a fair outcome. I think the question that I continue to have is whether or not DMHC doesn't have the authority already to do some of these things. It strikes me that they do. One of the points made by the panelists was just to enforce existing authority under AB 1455. the argument's been made that clearly there's authority there to address these issues. So I think we've got a range of solutions. I will close by saying that I have a set of questions that I had planned to ask the department, but the department is not here. And so I will ask that the staff take those questions and put them in the form of a letter to the director of the department with a request that she answer those questions, and not only to me as the chair of this committee, but to the other members of the committee who are present or not present, as well as the chair of the Assembly Budget Committee. I think important questions have been raised, and I have many questions of the department that have gone unanswered because of their decision not to participate. I have to say that I am extraordinarily displeased by the department's decision not to participate, or as it seems, if that decision was made at a higher level in the governor's office itself, the governor's office's decision not to participate. The process, our democracy, only works if the co-equal branches are able to communicate with one another, and if the legislature is able to perform its constitutional oversight function. That was clearly stymied in this case by the department and the administration's decision not to attend this hearing. I think it's extraordinarily disrespectful of the legislature, and I think it is something that bears commenting upon at some length, which is why I'm doing it. I've been in this legislature for 6 years now. I'm leaving, but I have yet to see a circumstance where senior officials of an administration refuse to participate in a legislative oversight hearing, as was the case here. It's extraordinarily disappointing, and I think something that definitely needs to be addressed. And it's my hope, and I'll be communicating such to the chair of the committee, what happened here. And it's my hope that the committee, the full committee, will take up this issue in the spring when it begins anew its deliberations on this department's next budget. So with that, again, I want to thank the panelists and thank all the members of the audience. And I will also be encouraging my colleagues on the subcommittee as well as the committee to take a look at the solutions that you have proposed, to consider them both as a part of the budget process, but also as a part of their consideration of possible bills for introduction at the beginning of the next legislative session. With that, I'm most appreciative, and thank you for those of you who are ER physicians in the room. Thank you for the tremendous service that you provide in communities across California. And with that, we are adjourned. Thank you very much.